Well, for certain individuals, they are required by law to have received a full course of the COVID-19 vaccinations, and those are particularly in the health care industry, and particularly those who work in Care Quality Commission registered care homes. And the law has changed recently over that, so those are compulsory, and therefore those employers are perfectly entitled to ask their employees whether they've been vaccinated, because it is necessary for them to comply with the legislation. Otherwise, government guidance does not require your organisation to conduct checks, and checks are entirely at your discretion as the employer. But what you want to do is to consider whether you need to have that information for the purposes of protecting your staff in the workplace or for delivering your services to the customers. And so we must remember here that vaccination is actually a special category of data for the purposes of GDPR, because it is in effect medical data. Now, what the Information Commissioner's website says is that you're perfectly entitled to ask someone about their vaccination status, but you must do so fairly and lawfully, so that you must use that information for a specific purpose, perhaps the health and safety of your staff, and keep it no longer than is necessary to do so. Well, the simple answer is yes, you can ask someone who's applying for a job about their vaccination status, particularly because it's in your discretion to ask that question, and particularly if it's a necessary requirement of the work, particularly if it's a customer-facing role where they may come into contact with members of the public. But you must have a particularly good reason to do so. So if you cannot work because of COVID-19 symptoms, or you've tested positive for COVID, then you can get SSP if you are self-isolating, because you or someone living with you has COVID-19 symptoms, or has tested positive, or you've been notified by the NHS track and trace system that you've been in contact with someone who's got COVID, or someone in your support bubble has COVID symptoms, or you've been advised by your healthcare professional to self-isolate in anticipation of a forthcoming hospital operation. Now, you can get SSP from day one of self-isolation, but to be eligible, you must be off for at least 4 days. So therefore, in those circumstances, if you're self-isolating under the new regime for 5 days, then you will get statutory sick pay for all of those days whilst you're self-isolating. Now, for employers, the good news is that from the 14th of January 2022, employers can now claim back from the government up to 2 weeks statutory sick pay that they've paid to their employees who are self-isolating. So that's very good news, and the government has changed that recently. However, if you have been double or triple vaccinated, and you have been tipped off that you've come into contact with someone who's contracted COVID, then you are not obliged to self-isolate, and in fact the government are saying that you should not self-isolate, so therefore you don't qualify for statutory sick pay. Contractual sick pay, or otherwise known as occupational sick pay, is paid by employers to staff who are unable to work, and it includes statutory sick pay, and it is a contractual right for the employee who is unable to work to be paid in full for their time away from work. So the question of whether an employer has to pay company sick pay or occupational sick pay to someone who has not been vaccinated is really hot news at the moment, and there's a lot of noise in the HR press about it. The unions particularly are unhappy at the thought that some employees who are anti-vaxxers, for various reasons they don't want to have the vaccine, are being penalised where they're unable to get company sick pay for any periods whilst they are self-isolating, as opposed to statutory sick pay, which, as I've just mentioned before, they are entitled to get. Now, where company sick pay is discretionary, employers have an absolute discretion to withdraw it if they wish. And some employers are making the point that if they are putting their staff at risk by essentially allowing anti-vaxxers into work to potentially infect those people, then if they are self-isolating, then they shouldn't be entitled to company sick pay. There is a risk here that by doing so, that some employees could claim unlawful discrimination on grounds of a protected characteristic, which could be gender, disability, religion or belief, or race or ethnic background. And as I say, there's been a lot of noise in the press about this. The general feeling amongst HR professionals and employment lawyers about this is that if the employer exercises their discretion not to pay company sick pay to an anti-vaxxer, then there is a risk of a discrimination claim, but potentially they could argue that they are objectively justified in doing so on account of their legitimate aim of protecting their staff from exposure to COVID-19. In other words, a health and safety legitimate business interest. And provided, so the employment tribunals say, that this is a proportionate means of achieving that legitimate aim, and there are other measures that they could take, but this is the more effective one, then they could withdraw company sick pay to any anti-vaxxer. Well, other companies, particularly the larger ones like IKEA and Morrison's, Wessex Water, have taken the decision to withhold company sick pay from anti-vaxxers. They believe that by doing so, they will encourage people to take the vaccines, and if they don't take the vaccines and they have to self-isolate, then they will only get statutory sick pay. But they have very firm policies and very firm legitimate business interests for doing so, which they believe they can justify. And I have to say, good luck to them.